The next questions that we have to address are more procedural in nature. Assuming you do have capacity, what do you do to get married? What are the procedures that you go through? Well, there are a number of different ways that you can get married, but the most important of them is what is referred to as ceremonial marriage. Ceremonial marriage has two requirements. And I should say before we look at them, that ceremonial marriage is the way in which 99% of most people get married. It is by far the most prevalent and most important procedural method for entering into the marriage relationship. The two requirements for a valid ceremonial marriage are a marriage license and a ceremony. You need a license and you need a ceremony. The license requirement is quite straightforward. You normally will procure the license from a state or local or county official, and the primary purpose of the licensing requirement is to enable the state to inquire into your marital capacity. That is the point in the process at which we can make sure that you're not marrying your sister. It's the point in the process that we can find out how old you are. It's the point in the process whether we find out whether you have an existing valid marriage. Most states require, in addition, a blood test certificate as part of the licensing procedure. The diseases for which you must be tested vary from state to state, and those diseases can be as brief a list as just syphilis, or it can be a much longer list of sexually transmitted diseases. In addition, in many states, there is a cooling off period between the issuance of the license and the date that you are legally permitted to get married. The license will be issued and it will be effective from 3 days after issue to 60 days after issue. The notion again is that the parties can reconsider, and if they choose not to go forward, they can rip up the license and they will not be legally married. We don't want to have a rush to judgment. That is not true in every state. Obviously, in some states there is no cooling off period. Certain states that have drive-through marriage chapels obviously are being able to facilitate these couples who are eager to consummate their marriage without awaiting a 3-day period. The final thing to say about licenses is a bit of an irony. While you are legally supposed to go get a marriage license, in a considerable number of states, the licensing requirement is characterized as, quote, merely directory, which is to say it does not affect the underlying validity of the relationship, assuming the parties have acted in good faith. So that if the parties do not get the license, or if there is a defect in the license, in those states that take this position, they are still married. There are a minority of states where the licensing requirement is mandatory and where the irregularity in the license may affect the validity of the marriage. But as I say, that is probably a minority position. In most states, we are not going to penalize the couple for an irregularity in the marriage. As I said at the outset, there are two requirements for a ceremonial marriage. The second requirement is the ceremony requirement. And the ceremony requirement is equally simple and straightforward. Unlike the licensing requirement, the ceremonial requirement is in some sense mandatory in almost every jurisdiction, because unless there is some solemnization of that wedding, some solemnization of that couple's commitment to each other, there is no marriage. The details of the ceremony are themselves entirely up to the individuals getting married. But there must be some ceremony to make sure that the parties know what they're getting into. In effect, it's like the requirement in contracts of a meeting of the minds. There must be that moment where they are made aware that they are exchanging mutual promises. Now, to be a little bit more formal about the ceremony requirement, the usual definition of a ceremony, the kind of definition that you might want to give back in an exam question, is a solemn declaration before an officiant and one or more witnesses. Who is the officiant? Well, states have different lists of potential officiants. My somewhat sarcastic summary of the law on who can be an officiant is anyone who looks important can be an officiant. Basically, clergy of any denomination judicial officers, a variety of high, medium, and in some instances rather low-ranking politicians, the mayor, the county commissioner, the justice of the peace. In some jurisdictions it may be ship captains, in some jurisdictions it may be special individuals whose sole function is to solemnize marriages. One or two other small points, and then I think it's probably a good point for us to pause. As I said before, there is no particular form of ceremony required, but you should understand this. The mere fact that you have complied with a religious ceremonial requirement does not make you married in the eyes of the law unless that ceremony is a ceremony under the definition we just observed. You may belong to a religious tradition, which involves having the two couples go off and sit quietly meditating in separate rooms for an hour, and when they emerge from the room, they are deemed to be married under that separate meditational period in the eyes of their religion. They would not be married under the eyes of the state, because that does not constitute the requisite civil ceremony that we look for. You hear what I think is an amusing but fundamentally inaccurate statement. You sometimes hear people say that common law marriage is the family law equivalent of adverse possession. And as we shall see, there is really not very much accuracy in that at all. The first thing to understand about common law marriage is that you need capacity for common law marriage just as you do for ceremonial marriage. Anyone who would have been incapable of entering into a ceremonial marriage will never be able to enter into a common law marriage either. If you cohabit with your brother, it does not matter how long you do so, you will never arrive at the status of a common law marriage. If two gay men live together for 30 years, their relationship will not be recognized in the law as a common law marriage. There has to be capacity. Second, there must be cohabitation. Cohabitation in this regard is not a euphemism for sexual intimacy. It means living together under the same roof as a husband and wife, with physical intimacy. If a couple maintains a separate residence, but they are frequently physically intimate with each other, they are not cohabiting, and they are not going to be ever deemed to be in a common law marriage. Finally, and perhaps most importantly, there must be some indication that at some point in the relationship, the parties expressed an intention to be married to each other and did so in words in the present tense. They have to have, at some point in their relationship, expressed an intention back and forth to each other to be married in words of the present tense. Why do I say words of the present tense? Well, because an expression of an intention to get married down the road will not make them into common law spouses. A statement in February, why don't we really make that, I want you to be my wife, why don't we make this official this fall? That statement, looking as it does to the future, will not be good enough. We need that statement expressed in the present. I consider you right now to be my wife. I consider you right now to be my husband. Now, one way to think about that requirement is to think of it as almost a self-ceremony, a self-conducted ceremony. Effectively, it's the exact same exchange of vows that we would have in a ceremonial marriage, except that there is no officiant and there is no witness. Now, the big problem that comes up in litigating about common law marriage is proof that the parties made that requisite commitment to each other. In most jurisdictions, you're going to have to prove that, indeed you are entitled to prove that, by circumstantial evidence. Direct evidence of the official utterance of the official words is usually going to be pretty rare. So we're going to rely on circumstantial evidence. What are the chief types of circumstantial evidence probative of the common law marriage? Well, first, reputation in the community. Reputation in the community. If everyone in the neighborhood or the village knows this couple and thinks of them as spouses, that reputation is probative that at some point they made the agreement with each other. Incidentally, depending on what jurisdictions you focus on, this reputation in the community is sometimes also called habit and repute. Habit and repute. Second, there must be public holding out by the couple, and that's another factor that we look at as circumstantial evidence of their relationship. Not only do others in the community regard them as husband and wife, but they represent themselves as husband and wife. They hold out. That can be as simple as putting a label on the mailbox that says Mr. and Mrs. John and Mary Smith. It can be small things like running into the dry cleaner and saying, has my wife picked up my shirts? Did my husband get my dress? Those kinds of issues constitute the requisite holding out. There is no minimum time period required to make out the common law marriage. The parties do not have to live together for 7 years or 3 years or any requisite period. The parties can get together, and if they have legal capacity, and immediately begin cohabiting and exchange the magic words, they are married. Now, as a practical matter, the issue of common law marriage will often come up after one of the two parties in the relationship has died. If both parties are still alive and both parties are getting along with each other, if there ever is an issue about their relationship, they can basically just come to court and say, no, we consider ourselves married, and that's pretty much conclusive. But the issue typically comes up after death. And it comes up because the surviving spouse is seeking perhaps an intestate claim under the estate of the decedent, or perhaps attempting to claim an elective share where state trust and estates law allows the taking of an elective share of the decedent's estate. It is at that point that we often have to make the determination as to whether or not there was a common law relationship in existence during the life of the two parties. So, for instance, if a woman claims rights as an intestate heir of a decedent man, that man's brother may be coming in and claiming as the sole surviving relative. We now have a contest between the woman with whom the man cohabited and the brother. Who is going to win? Depends on whether or not that woman can establish that she was a common law spouse. One other thing about common law marriage that is important to appreciate, common law marriage can be for many couples a fallback position in the event that there is some irregularity in what they thought was a valid and successful ceremonial marriage. And that's an issue that you should talk about, certainly, if you are studying in a state where common law marriage still exists, a state like Pennsylvania, or if you are analyzing a problem in a hypothetical or a fictional jurisdiction. So, common law marriage can be, in effect, a fallback position. Let me give you an example, not a particularly convoluted or complicated example, but let's say Harry is married to Alice. I'm naming her Alice because she's going to be the first of two. Her name begins with A. Harry is married to Alice, and Harry, H for husband, then gets a divorce from Alice, but there's a problem with that divorce. The court which issued it had no jurisdiction. Shortly after the divorce, Harry then goes through a marriage ceremony with Barbara, B, Barbara, the second spouse. This second marriage is, of course, bigamous and invalid. Harry lacked the capacity to marry Barbara. Harry was still lawfully married to Alice. The divorce was of no effect because the court lacked jurisdiction. But Harry was in good faith and he married Barbara and they lived together. Assume that some years later, 2-3 years later, Alice dies. Alice is in an accident or Alice dies of natural causes. Harry and Barbara are still together and still enjoying their life together. Harry then dies. Barbara asserts rights in Harry's will, in Harry's estate. You may be asked on an exam to discuss Barbara's rights. You would, of course, note that Barbara and Harry were not legally validly married, because when they entered into the ceremonial marriage, Harry lacked capacity. However, once Alice died, Harry no longer suffered from that impediment. Thereafter, the relationship between Harry and Barbara could be characterized as a common law marriage. After all, they were cohabiting, they were holding out, and there was probably reputation in the community. They were sexually intimate. It's a fair inference that they exchanged the requisite words in the present tense. We know they did it during their invalid ceremony. They probably can be assumed to have done it again during some course of their relationship. So that becomes a saving doctrine, a curative device, if you will, for Barbara to assert rights. One last word about common law marriage. It's a theme that we're going to take up on a number of other occasions. It's a theme involving conflict of laws. As I said at an earlier point in a different context, a marriage valid where contracted is valid everywhere else because the states, under the full faith and credit principle, will honor those out-of-state marriages. We noted that in the case of homosexual marriage, gay and lesbian marriage, that some states may refuse to give those relationships full faith and credit. But the prevailing rule with respect to common law marriage is much less controversial and much more straightforward. If parties enter into a valid common law marriage in a state that recognizes the institution of common law marriage, and then they relocate, even if their new home state does not recognize common law marriage, they will be treated as married in the new home state because they validly entered into the common law marriage in the original state. Indeed, some courts have stretched this almost to the breaking point in an effort to uphold relationships and do equity between the parties. There's a somewhat favorite case involving a couple, that lived in New York and liked to vacation in the South, I believe North Carolina. And during their drives to and from North Carolina, they frequently spent an overnight stop in Pennsylvania. New York does not recognize common law marriage, neither does North Carolina, but Pennsylvania does. And during their stays in Pennsylvania, they would register at hotels as Mr. and Mrs. X. They would indicate to people that they were married. They might introduce themselves to hotel employees as husband and wife, and they were cohabiting in their hotel room, and they were open about it. Court held that they had entered into a valid common law marriage during their brief interludes in Pennsylvania, and that New York chose to recognize that common law marriage because of the full faith and credit principle. Clearly, that is an example less of full faith and credit than of a court stretching a little bit to do equity between the parties. This couple had been together for many, many years, and it seemed to be the appropriate thing to do to honor that relationship. That's a kind of argument that you can use in analyzing a problem on an exam. There are two other marriage methods that you should be briefly aware of. These are very rare and of much less practical consequence. The first of them is known as proxy marriage. Proxy marriage is recognized in a number of states, and it is pretty much just what it sounds like. It is a marriage conducted in the ceremonial fashion, but one in which either, or perhaps both parties, is represented by someone else at the ceremony. In effect, a stand-in. All right? You might wonder why this would ever be done. You might think it's rather curious. What kind of relationship is this if you don't want to show up at the ceremony and stand next to your future spouse? Well, this is frequently done during military conflict when military personnel are abroad. If you want to get married, you may not be able to return home to get married, and so therefore what you do is you have someone stand in for you and the ceremony is conducted. Obviously, there can be both emotional reasons for doing that, but also practical reasons concerning your estate, perhaps benefits if you should die in a military conflict, and so on. So proxy marriages are recognized. The other doctrine that I would mention to you is something called the putative spouse doctrine. The putative spouse doctrine. P-U-T-A-T-I-V-E. This is another example of a saving doctrine that is designed to achieve an equitable result when the parties have made some kind of an error that results in a deficiency in their marriage status. Let me tell you exactly what the Uniform Marriage and Divorce Act says about putative spouse doctrine. Under that statute, any person who has cohabited with another to whom he is not legally married, in the good faith belief that he was married, is a putative spouse. Okay? So if you cohabit with a good faith belief that you're married, but in fact you're not, you are a putative spouse. What are the consequences of that? Quote, a putative spouse acquires the rights conferred upon a legal spouse, but those rights cannot supersede the rights of a legal spouse, but the court instead shall apportion property and support as appropriate. So what does that mean? Let us say we have one of these characters who occasionally crops up in the news, who is leading a dual life. He commutes between two cities that are 50 or 60 miles apart, and he maintains a separate household with a separate wife in each of the two cities. Clearly, the junior spouse, the second of the two wives, is not a valid spouse, because at the time that marriage was entered into, the husband was incapable of contracting a valid marriage. That second marriage is bigamous. So what is the consequence? The consequence under the putative spouse doctrine is that the second or junior of the two wives is nonetheless a putative spouse. If that man were to die, leaving behind two families, two widows, and two sets of children, the putative spouse would have a claim to property, to support, to a share of inheritance, and whatever under the putative spouse doctrine. As the Uniform Statute says, the court would make an appropriate division or allocation of the property. So that's how you get married. That's who's eligible to get married, and that's how you get married. I want to spend a little bit of time now talking with you about the consequences of being married. Now here I'm not talking about sociological consequences or emotional consequences, but legal consequences of being in a marriage relationship. The thing to understand about marriage is that although entering into the marriage resembles a contract transaction, having entered into the marriage, marriage is then a status. Unlike ordinary contract, the parties cannot entirely control the nature of the relationship. They can control some aspects of it, as we saw in the case of prenuptial agreements, but ultimately their mutual obligations are fixed by and subject to regulation by the state. Let's look at some of the features of a marriage. Many of these are just plain common sense, but I think it's useful to set them out in list fashion. First, duration of marriage. Marriage lasts for the life of the parties, unless dissolved by the state. A valid marriage lasts for the life of the parties. Second, there is coming with the obligation of marriage an obligation of sexual fidelity. The law imposes that obligation because in many states, adultery is a crime. Moreover, as we shall see, adultery is virtually everywhere a grounds for divorce. So there are a number of legal prohibitions that enforce the obligation of sexual fidelity. Third, married parties have a duty to economically support each other. A duty to economically support each other. That is a reciprocal duty. Each party owes that to the other party. There is no gender-based presumption in the law any longer. As we shall see in a number of other contexts down the road, the failure to engage in that support can be the basis for a variety of judicial proceedings to ensure that the support money is forthcoming. Fourth, spouses are given rights in the estates of each other when they die. These claims can take the form of either the right to inherit under intestacy laws, if no will has been drafted by the deceased spouse, or in many states the right to claim a so-called elective share. Elective share is a situation where, let's say, the husband dies and the husband has disinherited his wife. He's left all of his money to the fluffy shelter for stray cats. The wife is now left without any recourse under the will to obtain share in the husband's property, and so what the wife does is she files a claim for an elective share, and in many jurisdictions she's entitled to a third of the estate or even half of the estate under that provision. And one last incident of marriage that you should be aware of: married persons, and only married persons, may hold real estate as tenants by the entireties. So in all those regards, marriage creates specific and important obligations. On the other hand, for almost every other purpose you might imagine, married persons are treated as individuals. That is to say, they retain their separate identity and they retain their separate legal freedom of action. Let me give you some examples of that in some areas in which marriage does not change the relationship of the parties with outsiders, and it does not change their freedom of legal action. First, parties in a marriage may use any names they wish. The fact that they are married does not require them to adopt a common name, and there is no longer any requirement anywhere that a married woman adopt her husband's surname. Indeed, the courts have also said that parents have the right to give their children any surname that they want as well. Parents can adopt any surname for the children. So, for instance, the parents can use a hyphenated version of both of their surnames, or a contraction of both of their surnames, or they can use the father's name or the mother's name, and either way it would be acceptable. What else about married persons resembles the independent model that we're talking about? Well, married persons can own separate property. They're each entitled to own property in their own names. They can go out and buy that property and sell it, and there is no obstacle to their doing that. Married parties can contract. They can contract with third persons without needing the permission of their spouse, or they can even contract between themselves. They are not liable for each other's debts. The only exception is that in many jurisdictions, if someone sells a married person necessaries on credit, the other party in the marriage will be liable for the necessaries. Necessaries obviously meaning food and other items minimally required to sustain life and health, medicine, that sort of thing. And finally, married persons are sufficiently independent that if they do commit torts or crimes, they are individually liable for those torts or crimes. There is no group responsibility within the marriage unit, and they are perfectly capable of committing torts and crimes against each other. If a husband assaults his wife, he can be prosecuted for that. If a family member, a married person, negligently injures another party in the marriage, in most states there will be a valid claim of negligence that can be asserted. So that's how you get into a marriage, and those are some of the principal incidents or consequences of being married. That permits us to turn to our next broad area of inquiry, namely termination of the marriage. Termination of marriages. There are three principal matrimonial actions you should be familiar with, three principal methods of terminating a marriage. They are annulment, divorce, and separation. Annulment is the logical place for us to begin. And let me, as we begin with annulment, suggest to you the principal distinction between annulment and divorce. Annulment is the proper methodology of terminating a marriage when the grounds relied upon predate the marriage. Divorce, on the other hand, is a methodology that we use when the grounds arise after the marriage. It's a strictly chronological distinction. Look at the date of the marriage, and then look at the date of the conduct that is complained of as the basis for dissolving. If it's earlier, you're using annulment. If it's later, you're using divorce. There's one other distinction that I'd like to develop with you as we turn into the specifics of annulment, and that's the distinction between void and voidable marriages. Some of the grounds that we will be looking at as the basis of an annulment make a marriage void. Others make the marriage merely voidable. And that distinction is an important distinction, although, to be candid, less important now than it used to be because of the advent of a number of the curative doctrines that we were discussing. But let me develop with you at least three principal distinctions between void and voidable relationships. First, a void relationship is, as the name suggests, a legal nothing. It's an absolutely invalid relationship. It's void. That means that the parties are free to literally walk away from that relationship without any judicial order, without any further ado. It being void, they were never married, and they can simply walk away. A voidable relationship is binding and valid until you go to court and get that annulment decree issued. Having said that, let me caution you that in terms of counseling clients and in terms of answering exam questions, even in a void relationship, it is advisable to go to court and get an annulment decree. First, it's advisable to do that in the interests of clarity. You certainly don't want there to be any ambiguity about your marital status. Too much turns upon it. Everything from tax consequences and Social Security claims to insurance and ownership of various property interests that may be joint. You don't want to have any ambiguity, so you might as well get that annulment. Second, even in a void relationship, you may have acquired property jointly with your spouse, your putative spouse, your assumed spouse. You might have even had children in that relationship that we now think is void. Although you are legally free to walk away from that relationship, you may want and need the assistance of the court in adjusting your economic affairs or in dealing with your children. So, that's my first distinction between void and voidable. Technically, you don't have to go to court to dissolve a void relationship, but plenty of good reasons to go to court anyway. Second distinction. The grounds that make a marriage void are non-waivable. But those that make a marriage voidable can be waived by the parties. Grounds that make a marriage void are non-waivable, but those that make it only voidable can be waived by the parties. That, in effect, is one way to try to remember which grounds are which. The grounds that make marriages void relate to strong public policies of the state. They relate to state policies. Whereas the grounds that make marriages voidable largely relate to injustice between the parties, but do not implicate significant state issues. Since those grounds that make the marriage voidable relate to unfairness between the parties are free to say, I'm willing to look the other way, I'm willing to put up with it. That's why those grounds are waivable. I think that will become a little bit more vivid when we look at the individual grounds. So let's turn to the third distinction between void and voidable relationships. Void relationships can be collaterally attacked by third parties, but voidable relationships can only be challenged by the spouses involved. That's particularly important in these cases that occur after one of the spouses has died. If we have a relationship and it's void, and one of the spouses dies and the survivor is seeking to take the estate, another relative can show up and attempt to prove that the relationship was void. That proof of voidness will then defeat the claim of the surviving spouse to any share in the estate. That's a collateral attack on that marriage. But in the case of a voidable relationship, if the parties themselves have never challenged it, and now one of them is dead, nobody else can come in and challenge the rights of the other. One last introductory point, and then I think we should take a look at the individual grounds for annulments. In some jurisdictions, you will discover that there are different names for proceedings depending on whether or not the ground asserted is one that makes the relationship void or one that makes it voidable. For instance, in New York, if you are suing on a ground that makes the relationship void, the proceeding is called a declaration of nullity. Whereas if it is voidable, you would sue for an annulment. It's a small point, it's strictly a matter of vocabulary, but you should try to be aware of the terminology that's used in your own jurisdiction. That having been said, let us now look at the annulment grounds. In many respects, these track the various impediments or capacity problems that we've already seen. There are basically three grounds that make a marriage void in most jurisdictions. First, the fact that the marriage is bigamous. The state has a strong public policy in preventing marriages that are bigamous, and therefore that ground is not waivable. The parties cannot with full knowledge that the marriage is bigamous, nonetheless stand on their claim of being husband and wife. Remember, however, that somebody who enters into a bigamous marriage without knowledge of the bigamy and in good faith would be a putative spouse and have certain rights. Second ground that makes a marriage void: incest. No matter how badly that brother and that sister want to stay married, the state has a strong public policy in forbidding it. They can't do it. And finally, lack of mental capacity. If at the time of the marriage you were not lucid, if at the time of the marriage you were sufficiently suffering from a mental disease as to not know what you were doing, the state will not tolerate that marriage, and you are, of course, in no position to waive that, being, as I said, mentally incapacitated. So those are the typical grounds that make a marriage void. You can get an annulment for any of those. Now let's take a look at those that make a marriage voidable. There is some new material here. They're not only going to be impediments that we've seen previously, there is some new stuff. First, being underage makes the marriage voidable. If you get married and you are 17, let's say I have a 17-year-old female, and she marries a 19-year-old male, and the two of them begin living as husband and wife. 6 months into the relationship, the underage party concludes that it was a mistake. The underage party could then procure an annulment. But assume that they live together for 3, 4, 5 years, and then things get a little bit rocky. At that point, both of them having matured, and the younger of the two being well past the age required, there would no longer be grounds for an annulment. In effect, that would be a waiver of the ground by virtue of their conduct. A second ground, another one that we've seen before that makes a marriage voidable, is lack of physical capacity. If the parties get married and then one of them discovers that the other is incapable of performing intercourse, that party has grounds to assert an annulment. But it's waivable. You may discover that your spouse is sexually incapable of functioning, but you may decide that the relationship is still one that you want to stay in, and you can therefore waive the ground and retain the other aspects of that marriage. Another ground that we often see asserted for an annulment, another ground that makes the marriage voidable, is the ground of duress. The ground of duress is usually sort of defined or elaborated as undue influence or force that vitiates consent. In other words, you're forced to get married. The fact pattern that I suppose typifies duress is one that's easy enough to imagine. It's the shotgun wedding fact pattern. The young man and the young woman are physically intimate, and sure enough, the young woman discovers that she is pregnant. She informs her father. Her father gets his long-barreled shotgun, comes after the young man, holds the gun on him, and says, "We're going to the preacher, and we're going right now." Off they go and they get married. That's a marriage under duress. It's a shotgun wedding, and therefore the marriage is voidable, which is to say the husband can sue for an annulment. On the other hand, it's also waivable. If, after the coercion is removed, he chooses to stay into the relationship, that's fine, because he's entitled to waive the ground. Fourth ground that makes a marriage voidable. Fourth ground for annulment in this category, fraud. Fraud. If one of the parties in the relationship has either misrepresented or concealed an issue, that concealment or misrepresentation can be the basis of a claim for an annulment. The traditional rule here is that the fraud must concern subject matter that goes to a vital element of the marriage. That goes to a vital element of the marriage or an essential aspect of the marriage. Now, by vital or essential, some courts originally interpreted that to mean issues related strictly to procreation and marital relationship. But the more modern cases have opened up the categories a little bit broader than that and allow fraud to be asserted with respect to other issues that seem to be central to the parties' companionship or central to their ability to get along with each other. In effect, in these jurisdictions that take the more open-ended view of fraud, the fraud can concern anything that in a typical couple would be considered to be fairly important. There's one famous case where a woman, married a man and discovered only after the marriage that he was a member of the American Nazi Party. He festooned their house with swastikas. He insisted that she quit her job because her supervisor was Jewish. He told her that she was forbidden from associating with some of her black social acquaintances. All much to her surprise, since this had never once come up during their courtship. She sued for an annulment, alleging fraud, that he failed to disclose this. The court had to confront whether or not that went to the essential aspect of the marriage, and it concluded that it did. It concluded that she did not have to live in an environment like that, one that resembled the decorated assemblage at Nuremberg during the 1930s, and so she was held to have stated a good ground for an annulment. There are a number of categories or problems that can be thrown at you in a fraud hypothetical. Let me just allude to a couple of others so that you would be conversant with them. Misrepresentations concerning religion have been fairly widely regarded as sufficiently material to go to the essentials of the marriage, and therefore to be a ground for an annulment. If throughout the courtship one party assured the other that he or she was a devout Catholic, only for it to come out after the wedding that in point of fact this individual is an atheist, adheres to no faith, or for that matter adheres to a different faith, that would be fraud and it would be actionable. Similarly, misrepresentations concerning your intentions about procreation. Indeed, misrepresentations concerning your sexual proclivities. Those misrepresentations are also considered to be important and also considered to be, therefore, fraudulent and grounds for an annulment. If you indicate that you are committed to having a large family and love kids, and then when you get into the marriage relationship, you disclose that in point of fact, you do not ever plan to stop taking contraception because you hate kids, that would be fraud. The one type of misrepresentation that the courts have tended not to treat as sufficiently essential to the marriage so as to warrant an annulment is misrepresentation concerning finances, misrepresentation concerning economic wealth and economic resources. If you tell your fiancé during the courtship that you're fabulously wealthy, that you own real estate all over France and Germany and Italy, and that you'd like to spend half the year, each year, sojourning at these various places, and then, just after the wedding, you take your newly wedded spouse to some hovel located in a poor neighborhood of some major American city and disclose that you own no property in Europe and that you're actually a pauper, that will not be the kind of fraud for which an annulment can be granted. The law takes the position that people simply do not get married for money, that they're not interested in and don't care about the economic resources of their spouse. That may strike you as somewhat preposterous, but that's the position that the law takes. All right? Remember that this ground, because it makes the marriage voidable, is a waivable ground. If you stay in the relationship after learning the truth, then you no longer have the ground because you have waived it, and the marriage will be sustained, it will be valid. You discover your husband is a Nazi, and you say, well, that's cool with me, I don't have a problem with it. Then you've waived the ground. Your husband represented that he was a devout Catholic, but it turns out that he's an atheist. You say, that's fine with me. You've waived the ground. Two other grounds for annulment I want to mention to you. These are a little bit less important, but we do see a good number of cases about them, and so you should be aware of them. If one party can show that the other party entered into the marriage in jest, that would be grounds for an annulment. Makes the marriage voidable. Now, when I say a marriage entered into jest, that can be, of course, in the sense of genuinely a practical joke, but it might also be a situation where you sometimes encounter fact patterns where an individual will attempt to fool someone else into a marriage by hiring someone to pretend to be a clergyman in order to, in effect, seduce the individual involved. You know, John is very keen on being intimate with Mary. John understands that Mary would not be intimate with him unless they were married. So John asks his friend Paul to dress up as a priest. John proposes to Mary, goes before Paul, and there's a marriage ceremony conducted. Clearly not valid. Under those circumstances, that is a marriage that would be subject to annulment. it was entered into in jest, so that even if a state were to say that under those circumstances that marriage was to be treated as valid because there was an apparent authority on the part of the officiant, there would be grounds for the innocent party to extricate herself from that marriage. The other example of a marriage that would be voidable and for which you could get an annulment is a sham marriage. Sham marriage are those marriages that are carried out for tax or increasingly for immigration purposes only. Situation where you marry someone with no intent to cohabit, no intent to live as husband and wife, no particular bonds of affection between the parties, but merely to enable someone to obtain resident alien status in the United States. Those marriages can be annulled as well. Now, an annulment is a contested cause of action. There is a plaintiff, there is a defendant, there are grounds that are asserted, and consequently, you shouldn't be surprised to hear, there are affirmative defenses that can be raised in response by the defendant to the annulment. The typical affirmative defenses that you should be familiar with are 4 in number, none of them particularly complicated. First, we have a defense called laches. Laches. Laches is a classic equitable defense, meaning prejudicial delay. Prejudicial delay. What that means is that the plaintiff in the annulment must act promptly after learning of the defect. In effect, they will be charged with having waived the grounds if they delay too long before bringing cause of action. Long delay is the equivalent of laches. Second defense, there may be a statute of limitations in your jurisdiction. It's impossible to generalize about a subject as state-specific as that, but it's something that you should just be alert to. There may be a flat-out statute of limitations. Third, waiver can be asserted based on cohabitation after learning of the defect. Waiver can be asserted, in effect, by simply pointing to cohabitation plus knowledge. And finally, one can assert the equitable defense of unclean hands. Unclean hands. In other words, the guilty party may not be able to sue as plaintiff in the annulment context. Let's say we have Al, an American, who marries Jeanette, a French citizen, and marries Jeanette for the purpose of enabling her to emigrate to the United States. She emigrates to the United States, and having arrived, he is no longer desirous of being encumbered with the status of husband to Jeanette, so he seeks an annulment. He files a complaint against her, alleging the marriage was a sham entered into strictly to evade the immigration laws. Jeanette comes to court and defends with the defense of unclean hands. She says, you're right. It was entered into to evade the immigration laws, and you're the one who did it. You're the guilty party. You're the sneak. You're the sleazeball. And under those circumstances, Al may lose his complaint for an annulment because of unclean hands. This defense is also sometimes labeled equitable estoppel. He's estopped from denying the validity of the marriage because he, after all, is the one who entered into it and entered into it with full knowledge of the purpose.